All right, we are now recording. I'm going to introduce our two speakers today. We have with us Jeffrey Goetz. He leads the Bankruptcy and Reorganization Practice Group at Bradshaw, Fowler, Proctor, and Fairgrave PC. Jeff has nearly 30 years experience, and his practice primarily is focused on representing debtors in Chapter 11 reorganization cases. He's a frequent lecturer and panelist at state and national conferences, and he was named a Great Plains super lawyer and best lawyer in America. Jeffrey has led the firm to receive 4 Chapter 11 sale transactions to be recognized by the M&A advisor. We're also joined today by Julie Johnson McLean. She is a senior shareholder of the Davis Brown Law Firm in the business division. You'll recognize Julie today on the side panel, if you're looking for her as a panelist, as JJM81, a super cool code name. She has a general practice in, but not limited to, the areas of banking, bankruptcy, business organizations, and transactions, commercial transactions, and mergers and acquisitions. Julie provides legal counsel to lenders, creditors, and debtors in commercial transactions and bankruptcy matters. She represents businesses on a full spectrum of contract, commercial, and corporate matters, and advises buyers and sellers in acquisitions and dispositions and transactions of various sizes. I am very pleased to welcome both of our panelists and to hand it over to Jeffrey Goetz as our first speaker.
I'm muted now, right?
I can hear you.
Great. Well, good afternoon, and thank you, Jennifer, for hosting and moderating this. And it's a pleasure to speak with everybody today. We have a topic that is obviously touching most people's lives, especially in the business world here. I would just say, don't be scared, because the title has the word bankruptcy and reorganization in it. I know most people that sends terror to any business person. I would say just right off the bat that bankruptcy is obviously a last resort, and there are a lot of steps before any business or individual gets to a bankruptcy. Many people might not recognize a reorganization as an option. Some people have heard of Chapter 11. I would just use the general term reorganization and think in terms of continuing to operate a business while getting some relief from creditors and claims supervised by the courts. Think in terms of literally every domestic airline at one point or another has filed for and successfully emerged, reorganized through the Chapter 11 process. Reorganization is obviously available to individuals and to debtors. There's different chapters. Today, Julie and I are going to try just talking at a very high level. Don't want to get too far in the weeds, but do want to give you an idea of what some options and various strategies may be available to you. Julie, you were going to talk about some of the current remedies available from the creditor side. Why don't you discuss that?
Yes. First of all, I agree totally with Jeff that bankruptcy is a last resort. And I think from a creditor point of view, you can take certain actions to reduce your risk if you believe that one of the parties that you are working with may be in a distressed situation. For instance, if you're a customer of a supplier and you have concerns about the supplier, then you just need to make sure that you keep a good supply chain in place and to avoid inventory shortages and shutdowns, and you need to research and resource other possible suppliers. If you are a supplier and you believe one of your customers is in a troubled position, then you need to put top priority on getting paid, of course. Keep a very, very good watch on your accounts receivable to make sure that you're, on top of what's happening with your troubled customer. And then, of course, if you're a lender, you need to maximize your collateral value and your possibility and chances of getting payment and recovering in full. As a lender, you always want to work with your borrower, but at some point you have to get to the realization that it's, you don't want to continue throwing good money after bad. And that's always a good advice, but very hard to pinpoint. And it's, easy maybe to spot when you're Monday morning quarterbacking, but it's a tough one as you're in the business world. And whether you're a banker, a supplier, or a customer, it's very important to know in times like this what your contract terms are with your contracting parties. You need to know what the termination provisions are. If there's a force majeure clause, you need to know what that provides, what events might excuse the other party from performance, and just be on top of what the remedies are available to you under your contract. And I think going forward, force majeure clauses, I think have traditionally been kind of a contract boilerplate provision that people really didn't give much thought to. I think after this, or going forward now with the pandemic, we will be looking more carefully at those force majeure clauses and making sure they're specific and apply to what your concerns are, so that try to minimize the risk there. So anyway, there are, as a supplier, before a bankruptcy occurs, you do have many rights under the Uniform Commercial Code and remedies to withhold delivery of goods, even take goods back when they're in transit. And so, there are things to be looking for when you're concerned that your the party in question is in financial trouble. Oftentimes people say, well, how do we really know that? It's not like we are privy to their financial statements. And from a creditor standpoint, there are just sort of warning signs that maybe you should look for on an operational basis. If it looks like the quality is declined in this party, or maybe if there are delivery deficiencies, perhaps the party is relying on affiliates to provide goods or services. That's always an issue. If there's a high staff turnover, that's something else to sort of be a warning sign to be looking out for. If it looks like customers are declining, or if there are cutbacks, say, in capital expenditures, research and development, or employee training, those things can be a warning sign that the party is having trouble. Also, there might be management warning signs if there are changes in key managers or officers of a business that may be a sign that they are in financial trouble. And of course, if they employ financial advisors, that's of course another sign that there are issues out there. So, and then assuming we have time, I will, like Jeff said, like to talk a little bit about the CARES Act and also the Small Business Reorganization Act, which became effective on February 19th, 2020. And finally, I do want to address Governor Reynolds' proclamations and how those have affected creditor rights since March. Thank you.
Thank you, Julie. I guess if there's one theme that I would like everybody to walk away with today is that there are helpers out there, and that many people that have not in the past reached out to those helpers. Now is probably the time to break that habit and reach out to helpers. When I say helpers, helpers can come in many different forms. They can be your attorney. They could be your accountant. They could be a financial advisor. They can even be your banker. They can be your senior customers. There are a lot of different helpers out there, and many people, their knee-jerk reaction is, no, I'm gonna hold this all in. I'm not gonna let anybody know. These times are different, and I would recommend that if you have access to a support team, that you not hesitate to leverage that and reach out to them. In terms of what's available right now, I think most people know what the federal government has been offering in terms of programs through the Federal Reserve and the Small Business Administration. The payroll or paycheck protection program, affectionately referred to as PPP, not to be confused with PPE, personal protective equipment. But the payroll protection program, we know the first round went through all that money relatively quickly. There were some inequities involved in that rollout. We know that there's now the second rollout or supplemental funding of the PPP program. Unfortunately, when they did the rollout of the second one, they didn't necessarily change the rules that applied. They obviously recognized that there was a need to make these programs available to small or smaller businesses and that don't have or haven't had in the past the relationships with necessarily commercial banks, but alternative lenders like credit unions, even PayPal, what they call fintech, financial technology options. And hopefully the supplemental rollout will be more equitable along those lines. I would also recommend that people realize that there's two different categories of businesses out there that I come into contact regularly with. The ones that prior to the COVID-19 pandemic, most of my clients were those in financial distress or approaching financial distress and came in to get help and figure out, formulate strategies and implement action plans to salvage and keep the business healthy. Unfortunately, now we have a whole new section of a new group, which is companies that were formerly relatively healthy immediately prior to the pandemic, and now for the first time are facing financial distress that is not related to any systemic or foundational or market issue. It's specifically related to this crisis that we're all going through. I would tell people openly that although Julie and I, we know the bankruptcy code, we know what the bankruptcy rules are, but unfortunately, because of what's happened here, we don't have a clear playbook of how to deal with the financial distress that's come on as a result of this economic crisis and how to deal with it outside of general common sense business advice. So I know that I'm starting off right now advising clients, existing and new ones, that you have to go back to the basics. If you're going to have to start formulating a new strategy, when I say strategy, that involves both a financial strategy and many times business operational strategies. In order to do this, you want to make as informed a decision as possible. And we look to data. And by data, I'm talking about the metrics that individuals and businesses operate. We look to our financial books and records to judge the financial health. We look at other metrics for business operations. I think it's very critically important that if you're going to sit down with your helpers, whether that's your attorney, your accountants, your financial advisors, that you have the data available to you. There are plenty of times I come across clients that they have their financial books and records using the latest software and can generate the kind of financial information that financial advisors and accountants want. And then there are those that are still using hybrid, one computer system for point of sale and one for books and records, and they're not fully integrated. These are the times when you need to make sure that you have all of your data, all the metrics that you're going to use to formulate your new strategy moving forward. Sorry about that. Julie, do you want to give a quick update maybe on the CARES legislation and talk about some of the options available at this point from the government and state?
I'd be happy to do that. And Jeff and I were talking about this just before we went viral on this webinar. How much has happened. Jeff was talking about the primaries in the first Tuesday in February. And I look back at the timeline and it's just incredible what has happened since the beginning of February. And just sort of to put a recap on it, it was January 30th when the World Health Organization first declared the public health emergency on an international basis. And I think it was the next day, January 31, when the US Department of Health and Human Services also declared a national public health emergency. So, that was the end of January. Middle of February, the Small Business Reorganization Act, and Jeff may talk about this a little later, but it was signed by President Trump on August 23rd, 2019, and it had a 180-day period before it became effective. So it became effective on February 19th. With that background, then in March, everything geared up. And I think it was March 9th when Governor Reynolds issued her proclamation for a disaster emergency. And on March 11th, I think that was the date that the World Health Organization declared a global pandemic because of COVID-19, which they had named COVID-19. So Congress, as you know, got very busy in trying to put together relief for this pandemic. And they passed what we all refer to now as the CARES Act, which stands for the Coronavirus Aid, Relief, and Economic Security Act. And as a part of that CARES Act, they developed the what Jeff referred to as the PPP program, or the Payroll Protection Program. And pursuant to that legislation, there was, I think the first tranche of funds was $349 billion in that PPP program. And I believe that $349 billion was exhausted in 2 weeks, gone. And so they did authorize the second tranche, which is an additional $310 billion. I think that was approved by Congress on April 16th and became effective on April 23rd. So given the fact that you had the Small Business Reorganization Act coming online at the same time in February, you would think that these PPP loans would be available to provide assistance to those companies that are small businesses that are, in distress. And the PPP program specifically applies to small businesses with 500 or fewer employees. There are a few exceptions, but that's the general rule. And the loan funds are to be used to pay for payroll and certain other expenses, including rent, utilities, and mortgage interest. So under that background, you would assume that the PPP loans would be available to, again, help distressed small businesses. And what has happened when the SBA rolled this program out, they actually developed the rules for these loans, and bankruptcy was in their Q&A protocols that they issued. I think it was on March 24th. And one of the Q&As promulgated by the SBA was, the question was, will I be approved for a PPP loan if my business is in bankruptcy? And the answer was no, that if an applicant or an owner of an applicant, so not only the business itself or any owners of the business, if they are a debtor in a bankruptcy proceeding, either at the time the loan app is submitted or at the time that after the bank approves it and then disperses the funds, that applicant is automatically disqualified, is ineligible for a PPP loan. So timing is a big thing. So if you are in a distressed situation and you are, trying to get a PPP loan, you have to avoid bankruptcy until after the funds are dispersed, because otherwise, under the current SBA rules, you are disqualified from receiving or being eligible for a PPP loan. There are many challenges already that are across the country in bankruptcy courts, challenging these SBA regulations. So it's too early to tell what will happen, but that's out there, and it's unfortunate for those small businesses who are in distress, unless you can, wait it out and get your PPP loan prior to any bankruptcy filing, if that should be necessary.
Thank you for bringing up describing the CARES Act there. You referenced the small business legislation that Congress had passed. Just as a little bit of background, there are several different chapters of bankruptcy. Some are for liquidation, which is what's commonly referred to as Chapter 7 or straight bankruptcy or personal liquidation. That's where business is closed, everything gone. Then there are several different types of reorganization options available. There's reorganization specifically for family farmers and family fishermen, which provide an ability to reorganize, addressing the concerns for those particular industries. There's also been for a while provisions under the Bankruptcy Code for treatment of small businesses and who want to reorganize. Years ago, it was just one size fits all Chapter 11s. But several years ago, they decided to make a provision that, at least the intent was to make it easier for small businesses to reorganize. for those practitioners on the ground, we came to recognize that in some respects, filing as a small business was more onerous. But what they did do in August of last year is pass a law that looked at many recommendations that had been suggested by a blue ribbon panel organized by the American Bankruptcy Institute. And it was a study on the reform of Chapter 11. And because small businesses have very unique in the scheme of Chapter 11 reorganization, they tried to make changes and create a separate nook just for small businesses that really would give them a leg up. And I'm not going to get into all the details of that, but one of the most important things that was changed in the CARES Act was a specific provision that raises the eligibility of small businesses that used to be limited to companies that did not have more than $2.75 million worth of debt. Now, the CARES Act modified that jurisdictional limit, and now this new provision is available to companies that have debt up to $7.5 million. That brings in a lot more. And because of the few changes that they did make, it really does potentially leverage the ability of small businesses under this new, what they call subchapter 5, to reorganize. The problem right now is, as Julie pointed out, the law did not become effective until February. So there's only been a handful of these cases that happened. And unless the case had a problem, we would not see court decisions resolving a lot of the problems. Right now, the one issue that has been brought to many of the bankruptcy courts is debtors who applied for the PPP program while they're in bankruptcy that have made the argument that it was improper to have the SBA deny businesses in bankruptcy access to these resources. If you think about it, bankruptcy and reorganization is the process that salvages businesses, that saves jobs, that businesses to rebalance their balance sheet and continue operating, reorganized finances, and very often reorganized business operations. So it's kind of counterintuitive, at least for the debtor bankruptcy bar, to have this program be denied to the very people who have the highest success of reorganizing and coming out and continuing to keep people employed. I just wanted to say that last Friday, there was a judge in Texas who issued a temporary restraining order, which imposes a mandate for the SBA to, in fact, consider that debtor's application. I think in that case, it was an ambulance service who's in Chapter 11 and needed the money and would otherwise be eligible but for this bankruptcy prohibition. And just to put a fine point on it, many, many years ago, Congress recognized the impact of governmental agencies denying rights simply because somebody filed a bankruptcy was counterintuitive to wanting to rehabilitate, reorganize, avoid the loss of forfeiture, and allow people to move on with their life. And that Bankruptcy Code Section 525 basically says governments cannot discriminate simply because you're a debtor in bankruptcy. And apparently that is part of the argument that some debtors are making in court against the SBA that they shouldn't be denied just because they filed bankruptcy. Jennifer, are there any questions yet, or just curious?
Yeah, I'm not seeing any questions at this point. I do welcome our attendees, if they have something to ask, to go ahead and either speak up or write it into the chat. I will point out to you, are there questions that you commonly get asked?
Sure. I think the first thing that people, when people come to us for advice and counsel, it really depends on whether they come to us 2 days before a sheriff's sale or a court hearing versus those who come early. Those who come early obviously understand the old saying, prior planning prevents poor performance. So that's one reason, again, I want to emphasize, don't hesitate to reach out to the helpers. Whoever is available to help any small business or individuals, lawyers, accountants, bankers. Sometimes you have to talk with your primary creditor if their services or products to you are critical. You need to make sure that you cover all your bases so that you can continue operating under the best circumstances possible. I think one of the things that we have all seen, and sometimes it's hard for folks to really grasp, that everything in this global society is very interconnected. So that, for example, the restaurant that's closed down, it doesn't just affect the restaurant or its employees. It affects the food vendors, the wholesalers who are selling the proteins and the vegetables. And if they're not getting their orders, then how does that affect the producers, the farmers, the packing houses? Everything is interrelated. And I think it's hard for some folks to understand, kind of like a Jenga puzzle. You can't pull out one piece without worrying how it's going to affect every other piece. In terms of what people who come to folks like Julie and I, sometimes you just have to really, really start at the basics and get an understanding of the facts, historically, what's gone on. Not unsimilar to how important it is for your physician to spend a few minutes and get your history. You need to understand the background. The second is you have to have the data. You have to have the metrics. You know, it's one thing to say, well, I think my business is off by 25%, but if you look at the metrics, maybe the business is off by 75%, not 25%. You have to look at the metrics because it's the data from which we all have to rely on making informed decisions. And it's the informed decisions you want to make, not ones that are based on faulty premises or on an ad hoc basis where you reach out and you put out this one fire and then you have another fire. Just like the old saying, you only got 10 fingers to put in the dike. What happens when you have the 11th hole? So that's why I want to emphasize as a theme, it's important to reach out to those resources that may be available to you.
And from a creditor standpoint, I totally agree with Jeff on that. Communication is a key. And if you are having issues, I think as a banker or a supplier, you need to meet with management of your borrower or your contracting party and try to understand what's going on. And, is there a turnaround plan in place? And, I think it's communication is definitely a key. And outside of bankruptcy, hopefully you can enter into forbearance agreements or deferments. Given this pandemic with many, many businesses being closed entirely, obviously payments are going to be difficult to make. So communication is the key. I did want to, in the last few minutes, talk a little bit about how this pandemic has affected creditors' rights, and specifically in Iowa with Governor Reynolds' proclamations. And as most of you know, on March 22nd, Governor Reynolds suspended all foreclosures, and this included residential, commercial, and ag real estate. So that, per her proclamation, it suspended foreclosures, but it did not relieve individuals from making payments. So you were not relieved from making payments on your mortgage, but your mortgagee or your creditors were prohibited from commencing or continuing foreclosure actions. Then last Friday, April 24th, Governor Reynolds' proclamation went further, and it extended the suspension to Iowa Code Chapter 643, which governs replevins. Replevins is where a creditor goes to take back property. And the governor felt that a suspension of all Chapter 643 proceedings was necessary if the creditor was moving to recover collateral for non-payment of a debt. Again, your debt payments are not relieved, but the creditor's actions to replevin property are relieved. Also on April 24th, Governor Reynolds also suspended the ag mediation provisions, and that governs either the commencement or the continuance of any sort of action to proceed against agricultural property where you would have to go through a mandatory mediation ahead of time. And she suspended those proceedings that are subject to mandatory mediation. Finally, she suspended all garnishment actions that would apply, for instance, to a bank account or to public benefits or to unemployment insurance payments. Those actions, garnishment actions, have been suspended. And when she originally issued these suspensions, they were to go through April 30th, today. But on Monday, April 27th, these suspensions were actually extended through midnight Wednesday, May 27th. So that is the Wednesday after Memorial Day. So, and the interesting thing in her last proclamation is that she said specifically with respect to each one of these suspensions that Iowans should not expect that I will issue any further extensions of this suspension past May 27th, 2020. So if you are a creditor, you need to think about the plan that will go in effect on May 28th. You need to visit with your borrower or your contracting party, hopefully reach voluntary arrangements, whether it's a forbearance agreement or a deferment agreement, but hopefully this will be turning around soon, and hopefully Polk County will rise up to the level of the other 77 counties who are opening up tomorrow, and things will start to get back on track. But I did want to remind the attendees about those suspensions that are in place now with respect to creditor actions.
All right, I do have some questions to pose for you if you can stay on a little longer. How often are businesses able to avoid bankruptcy through reorganization and other non-bankruptcy means?
The length of time depends on the individual matter. It brings up a good point here that there are a lot of steps before bankruptcy. And before bankruptcy liquidation, we have bankruptcy reorganization. And before bankruptcy reorganization, the term of art we use is out of court workout. And that's where the parties, through their own efforts, without the need for court intervention, has the ability to reach an accommodation or an agreement. Very often, it could be something as simple as what Julie referred to as a forbearance agreement, all the way to reorganization of all their debt and credit facilities. An example would be if in the current circumstances, a particular credit facility held by a debtor is scheduled to mature today, end of the month. The bank may say, well, since we're prohibited from, declaring a default and foreclosing and taking aggressive action, the bank may realize that it's in our best interest and your best interest to basically declare a standstill for 30, 60, 90 days. That's a type of out-of-court workout that doesn't resolve the whole problem, but it gives the parties a period of time within which to breathe and make additional arrangements. The type of complete reorganization that's done out of court usually is a bit more complex, again, depending on the difference between a small restaurant and a medium or large size manufacturing business. Very different types of dynamics going on, but at the end of the day, out of court workout is obviously preferable to formally going into bankruptcy if you can do that. What I would tell you is that even though individuals who might have relationships with their bankers and it's a good relationship and you need some relief from your banker, you may just be able to do that by yourself. But more likely, you're going to have to present to the banker some information justifying or explaining what your situation is, why this is a reasonable request, in this case, for a 90-day forbearance. For example, the banker may be satisfied that the debtor received their PPP program. They know they have 2.5 months of payroll. They can keep things open. That might be an incentive or a basis for the bank to say, fine, we'll continue working with you. So yes, there are strategies available depending on the nature of your business, how severe your situation is, and how soon you attack the problem or address the problem.
Thank you. I have another question to ask too. What is the biggest reason people wait too long before reaching out to the helpers?
Julie's laughing. I'm going to let Julie. I'm interested to hear what Julie has to say. Julie,
I was more laughing at your terminology, the helpers. I think that it's difficult. It's difficult when you are in financial trouble to reach out. I mean, oftentimes you just hope. It's almost like putting your head in the sand. You just hope that things will work out. So I don't know if there's one reason why that happens, but it's tough. It's tough to admit that you're failing financially, whether you're an individual or a business. So it's just maybe just natural human instinct to try to keep a stiff upper lip and work it out and hope for the best, but it just doesn't always happen.
I think in general terms, there's the element of inertia. There's the element of fear. Sometimes people get a cut on their finger and it says, oh, it's just a cut, but a week later it's infected. you don't want to think that while it's getting infected over that week, that it's going to get worse. But in the case of running a business, and especially in this crisis period, inertia, fear, waiting, hoping, for a miracle, usually is not in your best interest. Being proactive, the phrase I use most often is formulate a strategy early, and once you have your strategy, implement an action plan. Go step by step. Make sure your plan is vetted. It's based on premises that you can support based on data. But again, it's different with a lot of different people. I think for some people, there's an element of, I can work this out myself. Some people confuse work ethic with asking for help. Some people say, well, I'm, whether it's machismo or ego or whatever, I'm not going to ask for help. Just like the cliche, the husband who's lost and won't ask for directions, Sometimes you just have to ask for help.
Thank you. We have just a few minutes left to the program today. So before we close up, I would just like to first of all, thank Julie and Jeff for being here today. Jeff and Julie, do you have any closing thoughts that you'd like to share before we conclude?
Well, first I would like to thank you and the Downtown Chamber for hosting this webinar, and to all those who are listening or watching. I believe you'll show our respective contact information. I'm available, my team is available to advise and counsel folks. Contact us by email or by phone, and we'll do our best to help you.
I think my closing comments are that from a creditor standpoint is that you should be proactive and commercially flexible given this pandemic. We don't know what to expect. And I think that keeping on top of the credit and being flexible will probably do you the best in the long term.
Thank you again. I'm going to go ahead and put your contact information back up here on the screen for everybody to see as we go ahead and finish up today. So again, thank you very much for your time and for joining us. As mentioned, this has been recorded. We will make this available on our COVID relief page found on dtchamber.com. Please make the information available to those who need it. We're very fortunate to have Jeff and Julie's expertise with us this afternoon. So again, here's the contact information. Write it down. Feel welcome to reach out. And again, thank you everybody for your time today. Have a good one.
Thank you, Jennifer.